My name is Harold Scott Roth here at the Hudson Institute. I'd like to welcome you to this session of the Center for the Economics of the Internet. Our guest today is Caleb Kruckenberg with the Pacific Legal Foundation. Mr. Kruckenberg was kind enough to visit us last winter to discuss the Federal Trade Commission in Section 13B. In 2021, the Supreme Court unanimously held that Section 13B does not give the Federal Trade Commission the authority to have monetary equitable relief in its investigations and findings. Unfortunately, it appears the Federal Trade Commission continues to seek equitable relief in various ways. I recently spoke with Mr. Kruckenberg, who told me that the Commission is still doing a lot of things in the same vein as Section 13B. And I thought it would be helpful to have him share his thoughts with all of us. And so I've invited Mr. Kruckenberg back to speak with us today. Mr. Kruckenberg, we look forward to your comments about what's going on at the Federal Trade Commission.
Well, thank you for having me once again. And I wish I had better news, but when we're talking about the FTC, particularly in this administration, we unfortunately have to talk about a lot of the same kinds of things. And, with this audience, I know this isn't a surprise, but FTC Chair Lina Khan has been a lightning rod for controversy throughout her entire tenure at the commission. Her most ardent fans point to her expansive view of the agency's role in the economy, an unrestrained understanding of the agency's authority to police private conduct, and its aggressive, unprecedented efforts to shut down entire business models. From the perspective of those of us who respect a less autocratic view of the commission's proper role, those same traits keep us up at night. Consider some recent statements from two of the commissioners when discussing Chair Khan's agenda. Commissioner Noah Phillips wrote an impassioned dissent from the agency's steps towards targeting tech industry for largely innocuous and, at least until now, legal practices. He called the commission's actions an attempt to, quote, recast the commission as a legislature with virtually limitless rulemaking authority. And in another dissent in the same commission action, Commissioner Christine Wilson laid the blame firmly on Chair Khan. She wrote, Chair Khan gave her no reason to believe that the chair harbors any concerns about harm that will befall the agency and ultimately consumers as a consequence of her overreach. Now, a lot of the attention, a lot of the discussion has been on the commission's rulemaking, and rightly so. But as I discussed last time, and as we discussed with Section 13, what makes rulemaking effective, what makes it concerning, is the agency's ability to impose sanctions. Because without consequences, their rulemaking authority is really, it is potentially meaningless or much less consequential. But if the agency can impose extremely large fines, billions of dollars of fines, even over the threat of violating their rules, they can push their agenda as far as they want to. Now, in the introduction, we mentioned Section 13 and the AMG decision. Now, traditionally, or at least for the last 40 years, the commission has relied on the authority in Section 13 of the FTC Act, which discusses the ability of the agency to go to court and get an injunction. And unfortunately, for a very long time, courts interpreted that to mean the agency could get a penalty award against any company for any violation of the rules. And often these awards had no relationship whatsoever with actual harm to consumers, actual profits, or really any concrete numbers. And the numbers that they got were billions of dollars. One of the most striking numbers that I can think of is in the AMG decision itself, the FTC got a $1.27 billion judgment against AMG Capital Management Company, which was a very small business. But after the court unanimously said that the commission doesn't have authority to get these kind of fines under Section 13, the commission was scrambling, and they have, since that decision, worked tirelessly to do their best to ignore it, to pretend like that decision was not effective, was inconsequential, and nothing has changed. Now, primarily, they've relied on another source of authority that Congress did give them, which is Section 19. Now, that statute was very specific. It allowed the commission to seek, quote, redress to consumers. And what Congress meant by that provision was essentially if someone takes something they're not supposed to, they defraud someone, then the FTC can force them to pay a refund. And that statute is very clear. It says that nothing in this subsection is intended to authorize the imposition of any exemplary or punitive damages. And in legalese, that means any punishment, any fines, anything above repayment of what was taken that they shouldn't have gotten. Now, the FTC always understood that section to mean that's just paying back, that's just restitution. And that's why Section 13 became such an important tool in their arsenal. Now that Section 13 is gone, the FTC has just gone back to this other section, and they've pretended that this goes as far as they want it to. This is their special tool to get all the same kinds of punishments that they got before. Now, I want to point to a few cases because it's easy for me to say the agency is misbehaving, but I want to highlight some very concrete examples. Now, the first is a case that I've been involved in as counsel, and it's called the FTC versus Credit Bureau Center. And this is a case that's currently pending in the Seventh Circuit Court of Appeals. Now, this case started before AMG, and like a lot of cases, this was a situation where the district court entered a disgorgement award under Section 13 of about $5 million. Now, the Seventh Circuit reversed that decision, and in a break with other courts said, actually, Section 13 doesn't allow this kind of remedy. When the court granted review in AMG, they also granted review in Credit Bureau Center. They granted both, and we know how that came out. The court remanded back for the district court to make another determination. Okay, no disgorgement, so what is an appropriate fine? Unfortunately, the district court in that case agreed with the FTC's argument that they could use Section 19, this other provision, to impose an identical remedy, once again to impose disgorgement. And that's what actually the district court even called it. Now, that is when my office, Pacific Legal Foundation, stepped in. We now represent that company on appeal. And in front of the Seventh Circuit, we argued that this is not what Section 19 is about. What's very interesting is I argued this case in June of 2022, and at the argument, the counsel for the FTC agreed that disgorgement, this equitable remedy that the agency was using for years, doesn't apply. And they agreed that the district court had erred by imposing a disgorgement remedy. And that the case really turned into exactly what kind of remedy is appropriate. But I think it's very telling. The agency ultimately was willing to back down in front of the court. But that's just one case. And we're still waiting on a final decision to see what the Seventh Circuit is going to tell us is appropriate. But meanwhile, there are other cases that I'm involved in where the same agency, the FTC, is seeking the same kind of remedy. There's another case that I'm involved in called FTC versus Consumer Defense. It's in the District of Nevada. And once again, it's the same process. Originally, there was a $19 million disgorgement award before the AMG case. After that decision, it was remanded back. And now the FTC is once again asking for an identical award. And they're even asking for disgorgement. They're saying we want all of the gross receipts from the business for the entire life of the business to be forfeited, paid to the United States Treasury for us to distribute however we think is appropriate. But they're claiming that under Section 19, this is akin to restitution to harmed customers. What's once again is quite remarkable about this case is just a few weeks ago, the FTC filed a notice with the court saying, well, actually, we agree that our ultimate request about disgorgement to the Treasury is probably unlawful. So strike that specific request, but we still want the $19 million paid to us to distribute as it sees fit. And I think once again, we have a situation where the agency is willing to ask for something that seems to be completely inappropriate. And as soon as someone litigates the question, someone fights back and someone appears in front of court, the agency will walk it back slightly. It seems like they know they can't get away with the entire request, but they're trying to push it as hard as they can. At the same time, these are two litigated cases that I've been involved in. There are another number of settlements that are going on right now that include these same kinds of forbidden awards. There was a settlement called In the Matter of Resident Home LLC, which under the commission's rules, when they enter a settlement, they have to open it up to comments, to public comments. This was a settlement they opened up to comments in October of 2021, which once again was after the AMG decision. And it included disgorgement. It included a penalty provision that it claimed under Section 19, but it said it was to obtain disgorgement of ill-gotten gains. That's the phrasing they used. Two commissioners dissented. I filed a comment on behalf of PLF against that settlement. And lo and behold, in July of 2022, the commission approved the settlement, once again with two dissenters. And as the two dissenting commissioners pointed out, quote, the FTC does not have authority under Section 19 to obtain disgorgement of ill-gotten gains. Yet the commission did it. And they know they don't have the authority. But because it was a settlement, because it was an agreement, they realized they could get away with it. And even as late as September 15th of this year, just a few days ago, the FTC issued a press release touting another penalty award that it claimed it was distributing to consumers in FTC versus Tate's Auto. But once again, this was an enforcement of a post-AMG award of disgorgement. This was once again a settlement. And that specific settlement said that any money not used for relief to consumers is to be deposited to the US Treasury, once again as disgorgement. So what kinds of conclusions can we draw from what is happening with the commission? Well, it seems the FTC is completely unwilling to accept the unanimous defeat that it suffered in AMG. And it continues to try to skirt that decision in piecemeal fashion and through settlements. Now, people like me, PLF, other litigants are trying to fight in the courts about this. And in a sense, we're playing whack-a-mole to try to force the agency to follow the rules. But individual litigation seems only to be able to go so far. And it's my hope that once again, the Supreme Court is going to have to take this decision up And once again, put the agency in its place and tell them that they cannot abuse the law in this fashion.
Mr. Kruckenberg, you mentioned a couple of recent settlements, such as Tate's Auto. Can you explain to our audience why a company would settle with the FTC even after the Supreme Court case?
Well,
yeah.
The issue with settlement and litigation strategy with the FTC, it's important, I think, to understand the way litigation works with the FTC. They have what they call an ex parte process that they use. And typically what the agency does in a litigated case is they'll go to federal court and they will get an injunction against a company without providing notice to the company. There is a process that they can use where you don't even know you're the target of the investigation. They will get an injunction against you, often with a receiver taking control of the company and your assets. And then they will approach you and say, would you like to settle this case or do you want to litigate this case? But if you litigate this case, just know we control your company, we've seized it, we've shut it down. And if you want your own assets to pay for your legal defense, you must ask permission. From that point, litigating a case is often impossible. And companies, unsurprisingly, settle as soon as they possibly can, which I think is a rational economic decision. But it's one that's really driven, I think, by the potential downside sanctions too, because, if we're talking about disgorgement or other very large equitable remedies, if at the end of the day, you're also facing $1 billion fine, something like that, there's absolutely no reason most companies will fight that.
And this is true both under Section 19 and Section 13B that
It is. And unfortunately, that's really what Section 13 allows. So Section 13 it really just talks about injunctions. And I think Congress made a deliberate choice when they set up the FTC Act. They decided that the commission could go to federal court in what they called extraordinary circumstances to seek an injunction. But they decided that penalties should be limited because of this other broad power. So the penalty that Congress they considered was you can get an injunction to stop specific unlawful behavior. You can order the company to pay back what they've taken that they shouldn't have gotten. That's it. But the compromise is that they can go to federal court, they can get an injunction, and they can use these sort of equitable tools to I think, put the company, the theory is to stop them from breaking the law, but in practice, it's really put the company in a place where they can't defend themselves.
And can you give our audience a sense of roughly how many of these cases, Section 13 or Section 19, that the commission brings every year, approximately?
Well, it varies. And part of it is we don't have good numbers because the commission, I think, is sort of cagey about what they'll do. Sometimes they'll approach a company before they get an injunction and they'll settle things very quietly. Sometimes they will be very aggressive and they will go to court, they will get an injunction, and really try to put the company out of business. I will say in recent years, the numbers are ticking up, certainly in the last few years under Chair Khan's leadership. And I think that targets have gotten more newsworthy and more robust. If you look at the press releases that the FTC is sending out, they're targeting major players now. They're targeting Facebook, they're targeting Google. I think the commission is really starting to behave more politically, more overtly politically, and they're really going after a lot of companies.
And so it's no longer just going after small and mid-sized businesses that can't possibly afford to defend themselves. They're actually going after large corporations.
They are, and actually there's a very large case that they filed against Walmart. And that, the traditional thinking has always been an agency like this, especially when it's skirting the law or really pushing a very aggressive view of its own authority, won't go after a big company that's going to fight it because they might lose. And they're not going to be that, they're going to be smarter about it than that. I don't see that same kind of calculation. I mean, they brought a major case against Walmart, and Walmart is fighting back, which is very unusual. And they are going to court. They have very competent attorneys that are fighting back. They're not sitting down on this one. And I think ultimately the commission is going to lose. I think they're going to lose a lot of their theories, and I think they're going to lose, they stand the chance of getting adverse court decisions that are going to limit their power. But I don't see that same kind of logical decision-making from the commission. And I really think it's a point of hubris from the commission, that they really think it doesn't matter. We're just going to do it anyway, and we'll see what happens.
Now, there are some in Congress who have introduced legislation to restore Section 13B. I believe Senator Klobuchar and S 4145. Can you update us on the status of that legislation?
Well, there have been a number of efforts, and I think they haven't progressed, and they haven't really gotten out of committee. And I think there's a very good reason for it. Because even though, right, you have a democratically controlled Congress, both houses, you have the presidency, they still haven't done any sort of legislative efforts to restore this that have, I think, any potential to pass. And I think part of that is a recognition that we don't necessarily want to give the commission that kind of authority. I think even Democrats are thinking that, because the FTC, like a lot of agencies, is a political entity. And we don't necessarily want to give a political entity what is essentially unlimited authority to impose whatever fine it wants against whatever target it wants. And I do think there's a concern, even among the Democrats, that someday there will be a change in administration and a change in priorities at the agency. And we don't want to be on the wrong side of that either. And so in some ways, I'm a little bit surprised, but not really. There really has been a deliberate effort, I think, not to give that power to the agency.
You mentioned Tate Auto, and I also had seen the press statement, which was very shocking, because it sort of said, the company's going to go out of business, and they're going to cease selling autos or something like that. It's pretty strong. And the FTC's proud of this. Is this something that they like, seeing businesses go out of business?
Well, it seems like it, and that's really what the press releases tout. And it's just like you said, that seems to be their measure of success, is to say, we've put this business out. We have ruined this business. We've shut them down. They can't operate anymore. Because there's a lot of really misleading language when the commission talks about the fines that they're getting, disgorgement, restitution, things like that. They always talk about it in terms of, we've gotten this money for harmed consumers. We've given your money back. And the reality is that's not what they're doing. And they're really often not even trying to do that. It's really a fractional percentage of the amount of money that is awarded to the commission ever goes back to any consumers. for the most part, they don't even try to collect them. It seems like the commission is more interested in shutting down the business than anything else. And I really think it's about press releases. It's about numbers. It's about being able to brag sort of as a commission, we've gotten this award, we put these people out of business. But it seems a lot less to be connected with, we actually returned this amount of money to a specific person who was harmed.
Well, in Tate Auto, I think there is some mention of a figure, something like 400,000 that was going to be distributed among 3,000 customers. I mean, the amount returned per customer did not really seem like a very large amount, given how much a new car costs. And I assume that Tate Auto had a lot more assets than that. So is the residual what goes to the U.S. Treasury? Is that what's going on?
That's right. That is the way the settlement was structured. And that's really the problem, because if you look at the Section 19 authority, this is the actual authority that the commission gave, or that Congress gave the commission. It says if you identify money that was taken improperly, then a court can order that you pay it back to the consumer directly. But what the commission is doing, and the orders that they're seeking and the settlements that they're getting, say, we want an award of all the money you made, whether it was connected with this particular misconduct or not, payable to us, the commission, and we will distribute it as we see fit. And if we don't, and we might give it in refunds, but if we don't, in our discretion, we will keep it. That's the way they've structured these settlements. And it's not, I mean, if you look at that, that is not about paying back someone who was harmed. That's about punishing a company, putting them out of business, and taking everything that's of value for the government.
Let me touch on a couple of other FTC topics and get your thoughts on them. First on privacy and then on corporate employees. There's a recent case involving a company in Idaho, Kokava, where the FTC is alleging misuse of customer information, and Kokava sued the FTC in advance. I guess they got word they were going to get sued. Is that a case that you followed at all, or?
Yes.
Tell us what's going on there.
Well, the commission, I think, is taking an extremely aggressive view of what is unfair. And I think part of the problem with the commission's actions in general is they're enforcing a statute that prohibits broadly unfair conduct. What is that? I don't know. And the commission is intentionally very vague about that. And something that's gotten a lot of press lately is they're proposing to make a new rule that talks about what's unfair when tech companies track customer behavior or things like that. Because the chair, I think, believes that when online companies track your spending habits, that's somehow unfair. That's illegal. But in this case, they've just run with that theory. They said essentially targeted advertisements in general are unfair. And if a company is using your information to figure out what kinds of products you like to buy, if they're tracking you across the internet, suddenly that's illegal, which I think is news to a lot of companies. I mean, I think this is something we all know about. This is something that's a common part of using the internet. And suddenly the commission is taking the position in litigation, this is illegal and we can shut you down and take all the money you've ever made. And guess what? Everyone else in the entire internet infrastructure is illegal too.
Yeah, it's hard to think of an online business that doesn't fall in that category. So is the FTC position that they have the authority to shut down the whole internet? Is that?
Well, it really seems like it. And I mean, if you use Facebook or Twitter or anything on the internet, I mean, if you go to the Washington Post, I mean, there are going to be targeted advertisements against, and it's just because that's how the internet works. We all know that. That's how advertising works. That's how people make money on the internet. And there's suddenly this position by the commission that by itself, just following your spending habits is somehow unlawful and is a violation of the FTC Act, and the commission can shut you down. I mean, it's really just a shocking position. And in some ways, I'm surprised that the company went to federal court proactively, but in other ways, I'm not. I mean, this is an existential threat for them. This is an existential threat for the entire industry.
To just drill down a bit, it seems that the COCAVA is also specifically about geolocation information, which is the type of information that COCAVA collects. And yeah, some people might say it's not entirely coincidental that this became an FTC case right after Dobbs, and
Right.
FTC was saying it's all about people going to pregnancy centers of some sort. Is there something unique or different about geolocation information relative to, say, browsing histories, or is there something different about that?
Well, I don't think in the abstract there is anything different about geolocation information, because again, this is the kind of information we know is tracked. I mean, if you have an iPhone, there's a setting. Do I want to be tracked or not? And you tell them. And I mean, at least for me, I allow tracking, and I know when I get in the car, it knows where I'm going to go. It says, you're 10 minutes from work or something. I'm aware of that. And I think a lot of consumers are aware of that. I think that the fact that they're focusing on geolocation in this specific instance, and if you read the complaint, there's all this talk about this kind of post-Dobbs, there's all this talk about sensitive information, like if you go to an abortion clinic or seek reproductive health care or something, that has nothing to do with this company. And I think the only reasonable way to view the complaint is this is an overt political maneuver. And in some ways, this is the commission filing a complaint, sort of grandstanding and saying, we don't agree with the Supreme Court, and we're going to make a political statement about, reproductive rights that has nothing to do with this case. That I honestly, I don't know another way to read what is going on there, because yes, I think in the abstract, geolocation, yes, it does implicate privacy concerns, sure. But I think most consumers make a choice. You can turn that information off or not. And again, this is sort of part of how the internet is operating.
Which sections of the Federal Trade Commission Act does the commission cite in the complaint? Under what authority does it claim it has the authority to go after COCAVA?
So Section 5, which is their generic ability to regulate unfair and abusive trade practices, just in general. And they say,
so what trade is going on here? Who paid what for, do they have the authority to go after trade in which there's no transaction?
Well, they certainly think they do. And they have taken the view, and in this case, I think they're taking the view that if COCAVA is collecting this information without explicit permission of everyone down the line, if they just somehow collect this information, whether they're the ones gathering it or not, whether they're the ones interacting with the public or not, then they're responsible and they are contributing to some general unfairness. And it is unfair in the abstract for a company to collect geolocation information about customers. That, I think, is their sort of grand theory that they're really pushing in this case. And as the company points out, that's not what we're doing, and we're not hurting anyone, we're not being abusive, we're not cheating anyone, we're not even taking money from people. We're just allowing the collection of geolocation information when they use certain apps, and they have a choice of opting out. I mean, that is what we're talking about. And that is like so many other companies.
And if Kakava were based in Bermuda or somewhere offshore, and we're doing the exact same thing, would the commission have any means of going after them?
No, not practically. And
so the net effect would be, if the FTC succeeds, all you're going to do is push online commerce, or not commerce, but online activity offshore.
Absolutely. And I mean, like, if you game this out, and if you really, if the commission is correct, if they're correct that passive information gathering from customers on the internet is always unlawful, whether it's geolocation or whatever.
Yeah.
Then you are telling Google and Facebook and every large tech company in America that your business model is a crime in the United States, and they will leave because Facebook is a lot bigger than the United States. They will go somewhere else, and if they have to, they will pull out of the US market. I mean, that's my sense. But if you're telling them that their entire business model can't happen, then they're not going to continue to play.
Yeah, well, you can see why the Center for the Economics of the Internet would be very interested in this type of view. If a federal agency views essentially the entire internet business model is inherently unlawful, then what is left? It's deeply troubling that a federal agency would take this view. Let me switch gears to a FTC press release from last Thursday. FTC to crack down on companies taking advantage of gig workers. I looked through the Federal Trade Commission Act. I was looking for the words employees. There's a lot of, it appears, I think 29 times in each case, it's about FTC employees. I'm not sure workers appears. And there's also been a lot of discussion about the FTC looking at antitrust in employment markets, which I think any economist would tell you is impossible, because there are lots of workers and there's no concentration of workers. So it's just, the whole thing doesn't make any sense. What is this FTC interest in looking at labor markets when it's not clear the FTC has any statutory authority to look at labor markets?
Right. I think probably the best way to understand the commission's thinking is, I think they're really working exactly backward of how they're supposed to be working. So, and what I mean by that is an agency is supposed to have a specific directive that they're then supposed to implement. So if they have a specific directive to prohibit unfair trade practices, which really should be understood as lying and cheating and stealing, and that's what we're talking about. They should say, okay, these are my marching orders. Let me go and look when people are lying and cheating and stealing, and let me stop it. But I think this commission under the chair's leadership is thinking about it in different ways. They're saying, what is my ideal view of a progressive economy? What's my ideal view of social justice or social policy that I agree with? How can I make that happen using the tools that I have? And it's not a surprise. It's not really shocking that they're now going after the gig economy, because these are the kinds of things that they're talking about, that the commissioner has, or the chair has been talking about since she was an academic. She says these kinds of things are abusive because the companies make money, essentially. But I think the commission's view is it's always inappropriate if there's a business model that we don't like, that we think is not being fair enough, that doesn't allow for unionization or doesn't readily lend itself to union workers or regular hours or something like that. And I really think it's a qualitative judgment and it's a policy judgment, and then they sort of work backward. So I think if the gig economy, if that rule is what we're talking about, they're saying, well, our general Section 5 unfairness authority, if we're talking about antitrust, unfortunately, the antitrust statutes are written that restraint of trade, economic activity that restrains trade is illegal. What does that mean? I don't know. And so they have so much ambiguity to work with that things are illegal if they say they are. And then it's really up to the courts to try to figure out, is this too far?
Yeah, I guess in my mind, there's this dichotomy between consumer retail markets, in which case I think the FTC's authority is pretty clear. But then when you get into labor markets, that just strikes me as a very different type of market, and one in which I think you've really got to have an elastic mind to think that there's any FTC jurisdiction in labor markets. And yet there seems to be extraordinary focus of the current commission on labor markets, and for some reason, particularly of all sectors, the gig economy, where workers, they're doing better than anybody else in the economy. I mean, tell me, why are gig workers at all should be the focus of the FTC when the FTC has no authority over labor markets? But if it did, you would think they might be focused on sectors where workers are not doing half as well as gig workers are. No, I'm sorry.
I think that's absolutely right. And I think you really identified a lot of the problem, and a lot of what makes this so unprecedented is, this is different in kind, in a very specific way. And we've seen that with all of the recent actions, rulemaking that the commission has taken. Even the chicken process, the chicken breeding tournament rule, which is something I learned about. And in chicken production, there's sort of a unique arrangement where individual farmers bid on chicken production and bid on contracts, and they call it a tournament. But even in that, in something that's just a part of this sector of the economy, the commission is now looking into that, and they're suggesting new rules for that, for how to regulate the way we grow chickens and farmers produce poultry. And it's really about trying to control large sectors of the economy. I think it is about imposing the commission's view of, the best of all possible economic worlds, how people should behave generally. And it's not about stopping specific behavior or, when people cheat or steal. It's about pushing businesses to behave the way they want them to, or have business models that they approve of.
So if there's another commission that comes down the road in a few years and they want to have some different view about business models than the Federal Trade Commission Act gives them authority to set the business model there as well. I mean, there doesn't seem to be any limiting principle here about what the commission can or cannot do.
There's not, and I think traditionally the commission has understood that they can fly too close to the sun. I think particularly after there was a lot of political fallout in the 1970s where the commission really was very aggressive, and Congress, I think, sort of stepped in, there was a little bit of a turf war. And I think since then, the commission has really respected that the rules that are written are extremely broad. And if they really run with it, there's no limiting principle. They can go as far as they want to. But if they actually do that, if they behave that way, then the courts, I think, are going to step in. And particularly now, I think the Supreme Court and lower courts have been very concerned about agency action in general, the FTC in particular. And I think if they keep pushing, the courts are going to stop them in very clear terms. But it doesn't seem like this commission appreciates that fact or cares about that fact. And I mean, I think with the penalty provisions, that's a good example. I mean, they've already lost that, but they don't seem to care. And I think they're really setting themselves up they're going to go too far. And the court is really going to come down and impose some limits, some much needed limits. And I mean, if that's the ultimate outcome, that's probably good, because again, the chair Khan is not going to be the chair forever. Someday there will be a different administration. And if we have an unlimited agency that can do anything it can think of, that's not good for anyone.
Speaking of not being there forever, Commissioner Noah Phillips, who, by the way, will be speaking to the center in a couple of weeks, has recently announced his retirement from the commission. Any thoughts on what type of new commissioner would be good for the commission?
Well, it's a somewhat unique situation where the commission has a statutory requirement of political diversity. And so we have a situation where the president will be able to choose Commissioner Phillips' replacement, but he will choose a Republican. And Commissioner Phillips has been, I think, a very strong advocate for a limited view of the commission. Time will tell to see who he's replaced with, to see if the president picks someone who has that same kind of principle, or someone who takes a very expansive view of the commission's power and simply has maybe a different aim for the commission overall. You know, my hope is that we'll have someone like Commissioner Phillips who will really respect the limits that are supposed to be there. But you know, time will tell. And at least now, regardless, we have a majority of the commission that seems willing to do anything.
Well, Mr. Kreckenberg, thank you so much for joining us today. I could go on, but I want to respect your time, very graciously given to us today to speak about the Federal Trade Commission. We look forward to having you back at Hudson Institute before long to update us. I hope with better news. I hope with the story about how things have gotten better. But in any case, we look forward to seeing you soon. Thank you so much.
Thank you very much.